Next to it.
He's right there. He's standing by 13. Actually, that's 9. Mm-mm. He gonna be, Reynolds gonna be, Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been called for jury duty for this particular week. You will be examined for an inclusion on a criminal trial. Our court hours are normally from 9 to 5. Whether you are selected as a juror on this case or not, you are performing a significant duty or significant service that only free people can perform. If you are selected on this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. You'll be permitted to separate yourselves for meals, for recess, and in the evening. I must administer to you the first of 2 oaths. And I would like to have each and every one of you to raise your right hand, and after I administer the oath, everyone please say, "I do." Hold on. Okay. All right. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a juror, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you can be considered for jury service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I will determine whether or not you are qualified to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover that the fact that you have been seated on this jury and you have not answered these questions truthfully, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I will ask you questions, but I need each and every one of you to answer the question to yourself. And then at the end, when I ask the last question, I will ask you, is anyone disqualified under the law? And if you believe that you may be disqualified under the law, you can simply raise your hand, and then I will ask that you come before the bench and we'll put this device on so that no one can hear what we are discussing. Again, I'll ask you a series of, I'm gonna ask one question at a time. You can answer to yourself, and then once you answer to yourself, we go on to the next question. And then once I get to the end, I will ask you, is anyone feels as though that they're disqualified? If you think you may be disqualified, you can just simply raise your hand, and then we'll call you up one at a time. First question, except for failure to register, are you a qualified voter in this county and the state of Texas under the Constitution and laws under the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause at this point because some of you may think once I ask the question, why is he asking that question? But I have to ask this next question by law. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified, please raise your hand. For the record, let the records note that no one is raising their hand. So at this point, everyone is qualified. Now I will move on to determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. And in the same manner, I ask the question, you can answer it to yourself. And at the end, if anybody is wishing to claim an exemption, I will ask that you will come forward. First question, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12, and your jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a pettit juror in the county during the three-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? If any of these exemptions apply to you and you do not desire to serve as a juror, please raise your hand. All right, just hold on a minute. At this time, we have one person that's raising their hand. We have juror number 3, David Terrell Howard Jr., is that correct? Mr. Howard, let me turn this off. You may come forward, and I need the attorneys. Let the record reflect that we're back in session. The panel is still present in the courtroom, and the attorneys for the state and attorneys for the defendant, as well as the defendant, is present in the courtroom. Now we will move on to excuses. If any of you feel there's a reason why you cannot sit as a juror, after I finish going over the excuses, we will ask that you will come forward to discuss that matter. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.01, Section 2C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state as well as the defense. And a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. At this time, we're going to ask that that juror number 19 come back up, Mr. Danny James Cannon. At this time, the court has completed the qualifications, accepting any exemptions or excuses. Now, let the record reflect that the court is still convened in cause number 324644. The case is styled the State of Texas versus Carlton Ray Goodman. Mr. Goodman is present in court. And Mr. Goodman is present with his attorney, Attorney David Grove. And the state is present with Assistant District Attorney, Attorney Lamar Johnson, and Attorney Raymond Shearer. Our court reporter today is Ms. Ada Christie, and she will be taking down everything being said, so speak up when you are answering questions. Our bailiff is Mr. Charlie Porter, and I think you've already met Mr. Porter. The defendant, Carlton Ray Goodman, is charged by information with the Class A misdemeanor offense of terroristic threat, family violence. The punishment range for a Class A misdemeanor is 0 days to 365 days, which is a year in the county jail or anywhere in between. A fine from $0 to $4,000 or anywhere in between. Or you could be given, or a person can be given both fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you prefer not to answer certain questions in the presence of the panel, say so, and I will ask you to come up to the bench so that we may discuss it more privately. I'll be keeping time. Now, at this time, state, are you ready? Defense, are you ready?
Yes, Your Honor, that's great.
At this time, the court is going to give each side 30 minutes. State, you may proceed.
Thank you, Your Honor.
You are. Yes.
Thank you, Mark Johnson. Good afternoon. My name is Mark Johnson. I'm Assistant Criminal District Attorney here with Jefferson County, and I'm honored to be here, standing here before you with my colleague Ray Shearer on behalf of the state and citizens of Jefferson County to select 6 of you to decide this very important case. Right now, this is the part of the case or the part of the trial called voir dire or voir dire in Latin, and it basically means, well, it literally means to pick the jury. So I'm going to be asking some questions, like the judge said. I'm not prodding anyone's personal affairs, but this is an important case. As you just heard the judge say, this is a case that involves family violence. So some of the questions that I'm asked, they may seem intrusive, but again, I want you to know that we just want to make sure that we pick the best jury and the right jury for this case. I want to remind you that there are no right or wrong answers. Your experiences are your experiences, and feelings are your feelings. We only ask that you be truthful with us, and we do the same in return. You took oath, and we're asking you to honor that. I want to start with a couple of preliminary I want to learn how to speak first, but I want to start with a couple of preliminary questions. Do any of you know any other juror, potential juror, sitting?
Yeah.
Oh, okay. The last, I want to say 3 trials have been, weird in the sense of a lot of the potential jurors have known each other, and a couple have been married apparently, because of that. So, Ms. CSAT, okay. How do you know Ms. I'm over here? Keontae, okay.
I work with her mother, she's a clinic. I'm a nurse at the clinic. Her mom's a nurse too.
Okay. Anything about that relationship would prevent you from being a very impartial? What about you, Ms. Sony? Same question. Anyone else? Anyone else? What about myself? Anyone? Anyone? Oh. I don't know if you're professional. Ms. Moore. This council here in Beaumont, and see him all the time. So, Mr. Reynolds, was anything about your relationship with me with the sheriff, with the court, with anything preventing you from being unfair and impartial to the trial? They would not. And you just heard the judge say the defendant in this case is Carlton Ray Goodman. Do anyone know the defendant? Thank you. Good. This counsel, defense counsel is David Grove. Is anyone familiar with David Grove? Or any interested in David Grove? Besides, Mr. Reynolds. Okay, I can get into this line for you. What about the judge? Is anyone, I'm sorry, Ms. Dana? Are you familiar?
Well, I don't really know him really. I don't really know him, but I know his school. She went to his school.
Okay. Is anything about their relationship with his daughter and your daughter, your kids, that would prevent you from being fair and impartial? Sure.
She's lost now.
What about the court reporter? Anyone? Let the record reflect that no one, I'll say this, I'll say, ask anyone to raise their hand. And maybe we're talking to myself, I'm ready to talk to the court before you have to get everything on the record. What about the bailiff, sorry, Porter? I'm sorry. Okay. All right. Okay. As I said, the defendant is charged with making several threats to a family member, and you know, while this is a important case, it isn't the case for everyone. We have our own life experiences, our own interactions, our own past, our own future expectations that shade how we think and how we think about certain issues, about certain people. So while this trial is important, it may not be the trial for you. And that doesn't make you a bad person. You don't have our biases. For example, if you were robbed 7 days ago, you probably wouldn't be the best juror for a robbery case. I would imagine that was with the fresh on your mind. The defendant here deserves a fair and impartial jury. Ms. James,
Yes.
do you believe that every trial would be for every person serving a jury on, serve as a juror on? Would you have an example of your own, or for one that you may think, make this juror isn't best in judgment of this defendant? Or any situation, kind of like the one I just said about Rob, 7 days ago, I wouldn't, shouldn't be picked on a robbery. Okay. Is there anyone that disagrees with, if anyone disagrees with, Ms. James, be very good. Oh, she said something like, a child abuse, if you were recently, been affected by child abuse, you on a child abuse, what different things. Ms. James. And Ms. Ward. Oh, say that. So has anyone, or raise your hand if you or anyone close to you has been a victim of family violence? Ms. Davis? And again, like the judge instructed, if this is something that you would rather discuss and talk about in private, that's something that we can definitely do. Would you mind telling me about your experience with family violence?
It was a long time ago. I was in my 20s, and he was not charged. But I did go to the hospital to see whether or not I was injured. But there's no record.
And so how do you feel that situation was handled by the police as far as the decision or the district attorney and the decisions not to charge him?
I didn't comment.
Okay. Do you think that makes him any less wrong for the violence, for the family violence? The fact that you didn't, well, let me back up. How would you feel about passing judgment in a case where the defendant, where the victim didn't go to the police, or the victim doesn't want to testify, but there is evidence, or the defendant was accused of family violence, but the victim did not want to go to the police? As far as, would you think that would make the defendant's, I guess, side of the story more credible or less credible?
I would have to know all the information. I'm trying not to judge.
Sure.
When I don't know.
Sure. Thank you. What about you, Mr. Lewis? Yes. What about you? If there's a situation where there were accusations of family violence, but the victim chose for whatever reason to not report it, how would that make you feel as far as the defendant's credibility, or would it make you feel anything at all? No. Is there anyone that disagrees with, regardless of whether or not a victim reports family violence, the act itself is, if there's evidence to support the act, that the defendant should nevertheless be charged and convicted for the family violence, even if the victim doesn't testify? Is there anyone that doesn't believe that? That the defendant should basically be left alone. Like if this is a family issue, and the family members don't want to report it, or the family members have some reservation about it, then the police should not, and the state should not get, put their nose in the situation.
Okay, do we? Are we saying that we would rather have, the police involved or let that family handle it?
So, yeah, so that's what I'm asking. Would you rather, would you still want the defendant to be prosecuted, although the victim did not file a complaint? Is there anyone who wouldn't want the defendant to be prosecuted if the witness declined to file a statement? Would you raise your hand? Am I tripping you up, Ms. James?
No, I feel like we can look at it about.
Okay. Are you comfortable with talking about it?
And if something happens, you know. We'll respect the word of probably grow.
Sure. I think, thank you, Sharon. With that, with your past experience, prevent you from being a fair and impartial jury in this case?
Family violence, it may be.
Okay, and a lot of cases are difficult, in a lot of situations, are difficult. I absolutely understand that, but would that prevent you in this case? And again, like I said, if it would, we're only asking that, I'm only asking that you be truthful, about it. So we know at the onset of this, because, the defendant has only been charged. That's not evidence, of his guilt at all. So, he deserves a fair and impartial trial, and we want to make sure that he gets that. So you think he could be a fair and impartial jury? Is there anyone else who has reservations? Thank you. And actually, Ms. David, if I can come back to you, is there anything about your past experience with family violence that would prevent you from being a fair and impartial juror in this case? Is anyone feeling like Ms. James in so much as having reservations about those?
That's my grandfather. He was abusive to my mother and my aunt, and then they also went through abuse in their first marriages. So I don't know. I don't know if I can be impartial because I've heard all the stories. And so I don't know. I mean, he did come from a very poor background, you know, he had, but I mean, I'm not gonna, I mean, I think God is the judge, you know, but I'm not gonna judge him, but I've just heard of that. I heard about that when I was about 12, and then I heard about it again, and it's always stuck with me, so I don't know.
And definitely understandable. But you took a thing, I'm only following up because you seem to have some kind of civic or reservation there. You did take an oath here right before the judge, not too long ago. So are you saying that you don't believe that you uphold that oath to be fair and impartial in this case, despite your past experience with family violence?
Well, I can try. I can try.
Yes, no.
I don't know. He's really trying.
Is there anyone?
What's that? Hold on a minute. Is that your, yeah, make sure everyone have their cell phones off. Oh, okay, you may proceed.
Thank you. Is there, thank you, thank you. Is there anyone else who may be a bit on the fence or have some worries or reservations about whether or not they can be very impartial in this trial because of violence or family violence in the past? Mr. Conkle, I have to come to you now. In situations where, and it doesn't even have to be family violence, but just in situations, and where violence, is a factor, you can fight, a screaming match that gets out of hand, or just anything. If the police are called and a defendant is arrested, does that insinuate anything as far as his guilt or innocence to you, solely from the fact of being arrested?
All people are arrested are guilty. You have to find out all the facts and what happened.
Okay, so you're saying that you have to hear all the evidence and make your determination as far as guilt or innocence from hearing the evidence.
Right.
Is there anyone who does not agree with Mr. Conkle? Thank you. All right, I want to move on a bit to more technical aspects as far as the law in this case. Does anyone know the burden of proof the law imposes on the state to convict the defendant of the crime he's charged? Does anyone know what that burden of proof is besides Mr. Remy?
Nothing beyond reasonable doubt.
That is Mr. Summer?
Yeah.
Okay, you said beyond a reasonable doubt. See, Mr. Remy, we got one person on here. That may got you. And to stay on Mr. Tomer, do you know what beyond a reasonable doubt is?
And a reasonable person being sound of mind and all the qualifications that we met would not have any doubts that the person or entity, depending on the case, committed the crime and have the ability to commit the crime as well. Of course, the insanity defense is also, but was able to.
Sure. And now I have to make one very, very important correction. It's you said that the state would have to, that the law requires the state to prove beyond any doubt that a reasonable person beyond any doubt. It's not. Excuse me, it would be a reasonable doubt, right? It would be a reasonable doubt, and that is because of law and order and a bunch of other things. There's misperception that the state has to prove their case beyond a shadow of a doubt, beyond all doubt whatsoever. And that just isn't the law. Let's see.
You have 10 more minutes.
Thank you. Ms. Gillis? Oh, how could, what's the only way someone would know beyond all doubt that something did or did not happen? Exactly, exactly. And no one here was, physically, where the defendant had alleged to have committed this offense. So there was just no way possible that they could ever meet that burden. Is there anyone who does not agree with that? Is there anyone who may know what beyond a reasonable doubt means? Well, that makes all of us in this courtroom, because there's no specific definition of beyond a reasonable doubt. It's what you feel a reasonable doubt is. Is it reasonable? Yes, this could have happened, but is that reasonable? That could happen, but is that reasonable? So it's one of my colleagues. When he does word diary, he always tells the panel not to leave their common sense at home when they come to the courthouse. And here it's a more formal setting, and you're doing very important work. You've been admonished by the judge to do certain responsibilities and certain things. So we can tend to leave our common sense in the car and try to be more rigid and force the state to show that there's no other way, that there's no way that the guy did not commit this crime, when that's just not the standard for the state. It's just beyond a reasonable doubt, and whatever reasonable means to you. If after you hear all the evidence and the argument from the counsel, it's what you believe is reasonable to have happened. And I wish I could provide you with a more concrete definition. But I would just ask to just not leave common sense at the door. I think maybe if we give you all some time back. I would just say thank you very much for your service. I am honored to stand here in front of you, and I look forward to coming case.
Mr. Grove?
Well, ladies and gentlemen, it's nice to get to talk to you. I'm not going to probably spend as much time as the prosecutor because he covered a lot of things, but there's some things that I think are very important that I would like to go over. As the judge told you, my name is David Grove, and I've been a lawyer here for almost 45 years, so I know you didn't think I was that old. No, you did think I thought I was older than that, but we won't get it. But it's my privilege today to represent Mr. Goodman. Now, when people come into a jury selection like this, you're here for the reason to be on a jury. And a lot of times when you see somebody like Mr. Goodman sitting over here with his defense lawyer, you wonder, what did he do? We don't say what is he charged with, but it's just the way that we kind of think. And there's nothing wrong with saying something like that, except that's not the way that the law in the United States works. Just because somebody has been arrested by the police, as we heard earlier, doesn't mean that they're guilty. Just because somebody is in here doesn't mean they're guilty. In fact, in the United States, as opposed to most of the countries in the Far East, people are presumed to be innocent. The prosecution has to prove that they're guilty beyond a reasonable doubt. And if we came in here and there was some evidence that was put on that, well, he probably did it, I submit to you that's not enough. Or it's more likely than not that he did it. That's not enough. This is the United States. In the United States, you have to prove that somebody's guilty beyond a reasonable doubt. And that is the highest burden of proof in any legal proceeding in the United States. Generally, in civil cases, we have beyond a preponderance of the evidence, which is just like 51%. To terminate parents' rights, as Mr. Reynolds knows, it's we have another burden of proof that's sometimes used by clear and convincing evidence, but that's still not as much as beyond a reasonable doubt. If you see a baseball game or a football game in Southeast Texas, you pretty much know who won that game, or well, it could be a tie, but you know who won it. But in criminal courts in the United States, you have to prove beyond a reasonable doubt the person did it, not anything less. And the way the system is made, you will see, as you have so far in the trial, that the prosecution goes first. I mean, they'll get up and whatever it is, they'll do opening statements first. They get up and ask their questions first. They put on their evidence first. And the defense kind of sits over there and waits. That's what we have to do. But the reason for that is because they have to prove that this man's guilty beyond a reasonable doubt. And if they don't do it, then we don't have any choice as jurors except to find it not guilty. Even if it's a tie, that's not guilty. I'm not going to tell you what I think the evidence here in this case will show, but we've heard quite a bit from several different speakers, the judge and the prosecutor, that this was a family argument or that type thing. And this happens, at least in my family, that happens quite a bit, where parties don't always agree. And based on my experience, and I imagine based on your experience too, I'm not trying to tell you what your experience is, but you know, sometimes we have family arguments. And sometimes one side wins, sometimes the other side wins, and sometimes nobody wins. Okay? And I submit to you that can be the same thing in any domestic violence case that you have. Just because somebody is charged, you don't have to find somebody guilty just because there was a fight or an argument or swearing at each other. Look at the evidence, and the evidence must prove beyond the highest burden in the state of Texas or in the United States that the person did commit the offense. In other words, you don't have to say that somebody won, and it doesn't mean the other side lost. That's not what we're talking about. We're talking about a criminal charge here. Now, many of you have been involved in other cases that sometimes happen, and several of you have indicated that you have been involved or even the victim in family violence cases. Okay? And to tell you the truth, that's pretty much the way it is with just about any family. We don't like to call it violence, but if it's in your family, that's pretty much what it can be. Now, that doesn't mean physical violence. And in this case here, I will be surprised if there is much allegation of physical violence as far as somebody getting the crud beat out of them or something like that. There may be, but I don't believe there will be, based on what I understand the evidence is. But again, is there anyone that's seated on this jury that feels like because they have been involved with their own family in some family violence, domestic violence, or domestic disputes, I guess, that they would hold it against this man here because he is the husband in this case? I think you can do what the law requires, and that is we wait to see what the evidence is and we weigh it, just like we would weigh anything else. And just because he is the husband in this case does not mean that he's automatically wrong. And since we have more women on this jury panel than we have men, that could be important. I don't think anybody would do that. If you have a problem with that, please raise your hand so we can talk about it a little bit. Like I said, the way this case will work is the prosecution will go first and we'll go last all the way through it. At the end of the case, again, I think that you will be able to make a decision based on your reasonable, your reasonable experiences. And I agree with the prosecutor that don't leave your common sense outside in the hallway. Just because you're in a trial does not mean that common sense is not important, because it is. And if you let it go, then there goes our system of justice. I don't have much else I'm going to say, because I think that you've done a very good job answering the questions, and I appreciate you serving as prospective jurors in this case. But just before we sit down, just because I've got a little time left, so I could do that. Generally, jurors never get to ask questions to the attorneys involved, okay? You're not supposed to. You're supposed to listen, and then the judge will tell you the questions, and you'll ask the judge's questions. Is there anybody that has any questions, though, they want to ask me before I sit down? I'm going to take by your silence if you just want me to sit down, and I will do it. Look forward to working with 6.
Okay, thank you, Mr. Grover, Mr. Johnson. Ladies and gentlemen, at this time, we're going to ask that you would follow the bailiff into the hallway, and the attorneys may have some additional questions to ask some of you. So just have a seat in the hallway. Now, of course, there's the restrooms out there, water. And if you need any water or anything, do we have some water here? Yeah, I think we have some. The bailiff can get that to you. So at this time, just follow the bailiff into the hallway. At this time, the court will be in recess.